Good afternoon, everyone, and welcome to the Planning Committee meeting of the 16th of December 2025. Just like to welcome members of the public attending today, my fellow committee members and planning officers and support staff. Just before we begin the meeting, just some important housekeeping notes. The meeting is being held live via YouTube and will be archived for future viewings. If I could ask all councillors and officers to please ensure you press your microphones on and when speaking and off when finished. If I could ask everyone to switch off their mobile phones or put them on silent. We're not expecting any live test fire alarms today, so if you do hear the fire alarm go, it will be the live call, so make your way out back the way you came in. Polite notice, if I could ask members of the public not to call out when individuals are speaking, as it will prevent others from hearing the debate. And before we move to the main agenda, if I could ask for all officers and members of the committee, starting from my right, to press your mics and introduce yourselves. And I'll start by myself. Is Councillor Arshad Afsar, be the chairman for this meeting today.
Naomi Perry, Planning Manager.
Lisa Bird, Principal Planning Officer.
Mark Evans, Staffordshire County Council Highways.
Councillor Monica Holton, Borough Councillor.
Councillor McHuckabee.
Good afternoon, Councillor Michael Slater.
Councillor Sheila McKiernan.
Alison Legg, good afternoon.
Colin Whittaker, Blythe Ward.
Councillor Jackie Jones. Councillor Chris Smedley.
Emily Thomas, Democratic Services Officer.
Daniel Corker, Trainee Solicitor.
Akil Adnan, Planning Solicitor.
Thank you. We'll now move into the main agenda for today. So agenda item number 1. Do we have any apologies for absence?
Chair, we have apologies from Councillor Bullock and Councillor George.
Thank you, if that could be noted. Agenda item number 2. Do we have any member wishing to declare an interest in today's meeting? No interest to declare. So moving on to agenda item number 3. If I could ask members to please accept the minutes from the last meeting held on the 25th of November 2025 as true. Could I have a seconder, please? Councillor Legg. Can I see a show of hands, all those in favour? All those against? Any abstentions? Thank you. Moving on to agenda item number 4. Do we have any urgent business to be brought to the committee's attention today? No, we have no urgent business. So moving on to the agenda item number 5, that's to consider planning applications today. So we have one application before us, planning application P2024-01084 is for the retention of use as an animal encounter experience, including the retention of a toilet/shower building, enclosed paddock area and the reception building, including associated parking areas and retention of a passing place along the access road. Site address is Rossin Farm, Scotch Hills Lane, Barton Gate, Barton under Needwood, DE 138DE. I'll now pass over to the planning officer to present the case.
Thank you, Chair. Good afternoon. As the Chair's just said, it relates to the application for Rossin Farm on Scotch Hills Lane, which is for the retention of use as an animal encounter experience, including the retention of the toilet and shower building, enclosed paddock area and reception building, and including associated parking areas and retention of a passing place on the access road. Negotiations did take place during the course of this application, and it was originally proposed for groups of 15 people per session, and that has been reduced to 8, and originally proposed for a maximum of 6 sessions per day, which is reduced to 4. So this plan indicates the application site. As you can see, it's in a rural location with fields surrounding it. The first section of the access road, the site is shown in the black edge. The first section of the access road is shared with neighbours who are situated here. There is a gate approximately here and a passing place that's been installed with a single track access to the site. The paddock area, this smaller area here has got 2 agricultural buildings within it, as we'll see on the next plan, one of which is proposed to be used during inclement weather. And the main plantation sort of area here is where the animal encounter experience is proposed to take place and where the buildings subject to the application are. There are footpaths nearby, but none of these are within the application site. And this is on Scotch Hills Road, which is this road here, and then Forest Road is this road here. So that runs from 5 Lane Ends to the north down to Barton Gate. So this plan just shows it a little more zoomed out to show the wider rural area. And as you can see, there are no listed buildings or conservation areas nearby the site. So this is the block plan. This indicates the paddock area here, where the experience is proposed to take place. There's a reception building shown to the north of the site, and the tiny rectangle there, the red rectangle, is the toilet and shower building associated with the proposed use. The agricultural building that's proposed to be used in inclement weather is this one here. There is a further agricultural building shown in blue that's not proposed to be used with this, with the proposals. The parking in respect of the site are in these locations here, here, here and here, and that long red line is the access into the site. The blue buildings that are shown on this plan are not part of the application. There is a separate application for this building here, which is a retention of a mobile home, and then there are 2 other buildings, which is a shed and a stables, which are unauthorised but our enforcement team are aware of. So this is just to show those buildings that are subject to the application a little more clearly in context with the surroundings. So there's the agricultural building here to be used during inclement weather. Access into the site runs through here, and the parking areas are here and running alongside the access there. That's the proposed paddock. The tiny rectangle is the shower and toilet building, and this larger rectangle is the reception building. So just some views of photographs of Scotch Hills Road and the access to the site. So this is a view towards Forest Road from the access, and this is in the opposite direction towards Dunstall Cross. These 2 are looking into the access at slightly different angles. So you drive in here and follow that road down. And then these are just to demonstrate that there are other neighbouring properties that have access from this road, and there is a gate here into the application site. These images show the access from the other point of view, so the access gate within the site looking just off the shared access drive, so that's looking towards the site. This is looking back towards the gate with the pass in place here, and then this one's looking into the site with the pass in place on the right hand side. And this image is just looking back towards along the access road towards Scotch Hills Lane, stood next to the agricultural buildings. These images indicate the photographs of access and parking spaces. So there's an informal parking area, several informal parking areas within the site. These have partly been marked out, but as members will have seen this morning, there was hay bales located on this part of the site here. Within this area, but there are further parking spaces that run alongside the access into the site. This just demonstrates the existing agricultural building, so that's the building proposed to be used during inclement weather. And then this image shows the buildings within the site, so going from left to right, we've got the reception building at the end, the mobile home that's subject to a separate application. the toilet and shower building and a shed that's not part of this application. So this just indicates an image of the reception building. We'd normally show you plans, but obviously the building's already in situ, so I've just put a photograph alongside that. And the following slide is similar in respect of the toilet and shower block. The paddock area is located to the west of the site, and that is just an enclosed area, enclosed with fencing, as you can see within the photograph below. So in terms of consultations, the County Highway Authority originally objected to the original consultation. Following the submission of amended details, the objection was removed subject to a condition that the development shall be operated in accordance with the submitted management plan. Staffordshire Police have raised no objections, and Nature Space raised no objections subject to an informative relating to great crested newts. And the Environmental Health team raised no objections, commenting that the site holds a performing animals licence for use in exhibitions and shows under the Animal Welfare Regulations 2018. The Parish Council did respond to all consultations, and on the original submission they commented as follows: that this appears to be a retrospective application. They raised concerns that the barn to be used in inclement weather is not shown on the plans. This has since been amended. It would appear, although it's not clear, that the animal experience is to take place in the plantation area. That has also since been amended. They queried if the operation and parking will take place in the plantation area and how this will operate. Queried if the animals roam freely and how the parking is separated. Commented that a rural location would seem to be appropriate for the type of business, but queried if it's a true diversification project in line with SP8. Raised concerns in respect of the impact of traffic and intensification of the use of the access track and private driveway. Concerns that there's insufficient evidence to demonstrate that the proposal is for the farm's long-term benefit, and raised concerns that there's insufficient evidence to demonstrate that this is a tourism project. In respect of further consultations, this was in relation to a reconsultation. The Parish Council continued to object and reiterated their previous comments, commenting that it's not clear if this is appropriate use of the land, that the drawings failed to identify the exact locations of uses, and that the 28-day permitted development right that the applicant is able to use is likely used up. That relates to 28 days per calendar years where events can take place from a site. They also commented that the details and status of the rights and of the private driveway would have been useful, although they noted that that's not a planning issue. On the final consultation, they made further comments and stated that whilst the efforts of the applicant are noted in respect of the amended details, the original concerns still stand in relation to traffic and impact on neighbouring properties and in respect of the principle of the development. In terms of neighbour responses, there's been 6 objections and 3 letters of support. In terms of the objections to the original consultation, these were in respect of the principle of development, where proposals do not show how buildings could be used for alternative uses, should not be considered as retention, and do not accord with the local plan. Just in respect of the retention comment, there's nothing in the planning legislation to prevent retrospective applications. In terms of impact on amenity, the comments were in respect of loss of amenity due to increased vehicle movements, increase in noise and disturbance, and car lights affecting neighbours. And in respect of highways impacts, no genuine choice of transport modes, no footpath in the immediate area, track becoming damaged, single track access not suitable for amount of traffic generated, vehicle access neighbouring properties in error, it's not possible to control people arriving early or leaving late, the local network not being sufficient for visitor numbers, highway safety concerns and increased risk of accidents, signage causing more congestion, and whose responsibility it will be to check the number of vehicle movements. Other matters were also raised in terms of incorrect site location plan, other unauthorised development on site, which we acknowledge and are either being dealt with by the enforcement team or via a separate application. Several other facilities in the locality and impact on human rights. The letters of support in relation to the original consultation were in relation to the operation providing a great experience and benefit for mental health and being good for kids. There was a further reconsultation and 3 objections were received to that. In principle, that the proposals do not comply with the local plan policies. In respect of highways impacts, it was reiterated that concerns previously raised and concerns over increase in numbers and vehicles totaling more than 100 at peak times, leaving at about 5 p.m. and other matters reiterated other unauthorised buildings on the site. In terms of further publicity and representations, Councillor George did comment on the access arrangements to the site. The policies used in determining the application are the MPPF, the ESBC Local Plan, the East Staffordshire Design Guide, SPD, and the Parking Standards, SPD. In terms of the assessment of the application, in principle, the proposal is considered to constitute farm diversification, which requires a countryside location. The existing lawful use of the land is agricultural, and the proposal would support the existing lawful use in compliance with policy SP8 and also complies with policy SP14, as it's intended to make a long-term contribution to sustaining the agricultural enterprise. On balance, the proposal is supported in land use terms. In relation to the design and impact on the character or area of the landscape, the proposals are acceptable in terms of visual appearance, being well screened from public vantage points, with the buildings and land being situated within an existing plantation. The buildings are small scale and of an appropriate design and material for this rural location. In terms of residential amenity, the experience itself does not generate a significant level of noise and disturbance. However, additional traffic is generated, which is proposed to be managed by spacing out the experiences a maximum of 4 times a day in peak season. No concerns in respect of noise have been raised by the environmental health team, although it is acknowledged that objections have been received. It is considered that the activity itself doesn't have a harmful impact on residential occupiers, and the increase in vehicle movements can be controlled by planning condition. Given the staggering of the events, the proposals are not considered to result in a harmful level of noise and disturbance. In relation to highways matters, whilst objections were received to the original consultation, these have been removed following the submission of a management plan in respect of traffic, which includes site signage. The parking area on site can accommodate 20 vehicles, which exceeds the level of parking likely to be required. The Highway Authority have not requested visibility displays. The site is not well served by non-car modes of transport. However, farm diversification is supported in the local plan, and generally this would take place in the countryside where transport options are more limited. In respect of ecology, the development is located within the red and amber consultation zones in respect of great crested newts. Nature Space were consulted and have confirmed that the development is unlikely to cause an impact on great crested newts and their habitats, and have no objections subject to a condition setting out reasonable avoidance measures and an informative drawing the applicant's attention to their ecological responsibilities. Given that the development has already been carried out, the condition in respect of reasonable avoidance measures is not considered necessary in this case. In conclusion, the proposal is considered to comply with the local plan, Parking Standards SPD, East Staffordshire Design Guide SPD and the National Planning Policy Framework. The local planning authority has worked proactively with the applicant to secure a development that improves the economic, social and environmental conditions of the area in accordance with the National Planning Policy Framework, and the recommendation is to approve with conditions as per the report and update sheet. Thank you.
Thank you. We do have an update sheet on this item. I take it all committee members would have received and have looked through that. We have a number of speakers on this item as well. So we have 3 speakers on the item. So just to note on this item, a member of the speaker has asked not to be filmed. So this means cameras will not focus on the public speaker during this meeting. However, the recording will still capture audio. So if I could ask for David Sturman to come forward. When you're ready, just press the mic. 3 minutes. There'll be a clock at the back, and just turn it off when you finish, please.
Can everybody hear me? Good afternoon, Chair. Thank you for the opportunity to speak. My name is David Sturman. Myself and my wife Sarah own Forest Barn, and we own the actual access road up to the boundary gate with Rossin Farm. We've lived there since July 2013, and before 2020 have had no issues at all with agricultural access up and down the track from a neighbouring farmer that still farms the adjoining land, and also the previous owners of the land that now is Rossin Farm. No real issues until a couple of years ago when intensification started and change of use, all without planning permission in the last couple of years. And I think your officer's report itself does state that this is a finely balanced issue. In summary, 4 objections: unsuitable access, a nuisance, obstruction and loss of amenity to us as neighbours. And please note, all 5 of the neighbouring properties that are directly affected by the activity here have objected, as have the parish council. Inadequacy of the amended proposals to mitigate all of that, and we have written in line with similar concerns from the parish council around the non-compliance with plans, and clearly there's a difference in interpretation there. In terms of the unsuitable access, Highways have reversed their original objection. It would be a question for your Highways colleague as to what has changed. Quote, "It does not constitute sustainable development and it's entirely reliant on private cars," unquote. And that was the original basis of that objection to the original application. So what has changed other than the volume of cars has reduced, which is acknowledged? Scotch Hills Lane itself is a single track public highway for most of its length, including the junction with our private driveway. Our private driveway is not suitable for high volumes of public traffic. It is a private driveway and it's simply not suitable for tourist attraction traffic. There is no public transport, lighting or pavements nearby, and that road is a 60-mile-an-hour de-restricted public highway. So there is potential for accidents. The traffic over the last period during these activities does disrupt our private family life, and there are Article 1 and Article 8 issues in our opinion. Our vehicle garaging is at the top of the drive at the junction with Scotch Hills Lane, and we've experienced people obstructing that and actually trespassing the garages during the activities. And I would invite you to consider the totality of activity on the site, which does include now camping, glamping and other potential tourist activities as well. There is no public right-of-way on that driveway in our ownership. All of that traffic issues and obstruction are a concern, as it is a concern to our neighbours. And in fairness to the planning officer who inherited this case from her predecessor, she's commented on the impact but hasn't actually been on the site, as I understand it, when these events have been occurring. So I would query her ability to accurately reflect the impact on amenity for the neighbours. It would be fair to say that we feel under siege in our own homes at times when these events are occurring. That's all I've got to say. The only addition would be the various plans that we feel it doesn't meet in terms of the assessment, and I thank you for your time today.
Thank you. If I can ask for Philip Jackson to come forward, please.
Good afternoon. My name is Philip Jackson. My family and I live at Chase View, one of the residences off the single lane track that leads to Rossin Farm. We have lived there for nearly 30 years without a concern until about a year ago when the animal petting events began. We have no issues with the farm's legal activities and indeed wish them good luck in their ventures, as long as they are not to the detriment of neighbours' peace and safety. Our objection is based around the considerable increase in vehicular traffic to both Scotch Hills Lane and the private single track, both with soft verges, no footpaths, no lighting. The committee today only witnessed the site whilst activities are closed. It is the weekends and holidays when chaos ensues. On top of the vehicles and pedestrians visiting the animal experience, there will also be traffic serving the farm's inhabitants, staff, deliveries, visitors for the glamping, weddings and parties. I don't believe the applicants are aware of the traffic issues on the single lane track, as they live a quarter of a mile away at the far end of the track and don't see it. You may have noted today the array of traffic cones on Scotch Hills Lane, positioned by neighbours to protect their drives and verges. In busy periods, cars regularly have to reverse back up the track to allow others to escape or pull into neighbours' drives. We positioned our waste bins at first at the entrance to our drive. On more than one occasion, I saw farm guests actually moving our bins aside so they could pull in. I now deploy a chain across our drive, which is most inconvenient. Each time we or our guests or delivery drivers leave or arrive, they must get out of the vehicle, remove the chain, drive across, then reattach the chain. When farm guests leave in winter, when it's dark, their headlights shine directly into our home's windows. I've been verbally abused on various occasions when asking farm guests not to pull into our drive, and physically threatened twice, once which led to police involvement. Noise, loss of privacy, dangerous traffic. What used to be a quiet corner of Barton Gate is fast becoming a tourist destination. It is my responsibility to protect my property and family, and today, members of the committee, it is also yours. Please turn down the application for the animal encounter experience. Thank you.
Thank you. If I can ask for the final speaker, Janelle Rose, to come forward, please.
Hello. So myself and my husband are the owners of Rosen Farm. We're first generation farmers and wanted to focus on helping to preserve native British breeds when setting up farming, which included the Highlands. After a number of years, we decided to try and allow the public to come and interact with them, and we had no idea how valuable this experience would be for members of the public. Initially, we ran a small number of sessions per day with a small number of participants, but after discovering we required planning permission to run the experiences, we've been running days with more sessions and visitors, as we've been limited to our 28 days for the permitted alternative use. However, we want to minimise the disruption on neighbouring properties. So in an attempt to compromise, we've proposed significant restrictions on ourselves, which are noted in the supporting statement. So this would limit us to 3 sessions per day and 4 during peak periods, as well as limiting us to 8 participants per session. We very rarely get bookings for individual guests, with the majority coming in groups of 2, 3 or 4. Therefore, per session, we would expect 2 to 4 cars. Therefore, per day, 6 to 12 cars, and during peak periods, 8 to 16 cars per day. After speaking to neighbouring residents about their concerns, we also put in measures to overcome them. So the issues were cars pulling into the driveway or trying to pass each other on the shared aspect. Therefore, we proposed a restriction on ourselves of 1 hour spacing between each session. Visitors generally arrive around 15 minutes prior to their session and leave around 15 minutes after. Therefore, that should avoid vehicles meeting on that shared aspect of the driveway altogether. We've also installed a passing place on our land and introduced a traffic control system. So in the rare occasion, if some vehicles do meet, they have the option to pass on our land rather than on the shared aspect. The other issue was visitors struggling to find us, so disturbing neighbouring properties asking for directions. To overcome this, we immediately produced a sign for the shared aspect of the driveway to direct visitors to us without the need to disturb neighbours. Our land benefits from right of access over the shared driveway in the deeds, which are as follows: a right in common with all other persons having similar right and those authorised by the trustee to pass and repass over and along the access way with or without vehicles for all purposes, for access to and egress from the adjoining land to the public highway at all times. I'd like to say as well that our experiences don't take place in the evening, and these restrictions as well would do that. So our latest session would be 5 o'clock in the for a peak period, but most of the time it would be 3 o'clock that they would end. Although we're proposing a much reduced number of visitors, The visitors we have come from far and wide, with many staying locally, eating at local pubs, cafes and restaurants, and visiting other local establishments, which all helps to support the local rural economy. Another concern that has been flagged up is the additional traffic due to the glamping. However, this is on an extremely small scale, with only 5 tents, which are for visitors travelling from further afield for an experience to stay on site. We very rarely have campers who are not already visiting us for an experience, therefore not having additional traffic. Thank you very much for taking the time to consider our proposal.
Thank you. I don't have any further speakers now, so I'll open the floor up for debate for committee members. Do I see any committee member wishing to start the debate? Councillor Slater.
Thank you, Chair. Yes, now Highways are here as well. I'd just like to know from Highways and our officers what arrangements there are for monitoring the vehicle use of this site. It seemed Highways gave a long list of objections in the first session and now have reduced it to nothing based on the fact that we're having limited number of access. But it just seems that there's going to be a temptation for mission creep, perhaps. So I want to know if you could respond to that, please. Thank you.
Yeah, just in terms of monitoring, the only monitoring we as the Borough Council would do would just be to respond to complaints that we would get. We wouldn't do any formal monitoring as such, and the county highways wouldn't do any formal monitoring either. So it would be quite reactionary, responding to complaints that we received.
The residents are doing it themselves, then basically they're going to, yeah.
In essence, yeah.
Yeah, and it does seem a bit of a shame, really. But fair enough. I'll stop there. Thank you. Thank you.
Councillor Jones.
Could I just ask the question that the objector asked of the Highways Department? What's changed? I think they were quite keen to hear what the change was from the original objections that came from County Highways to the now approval. Thank you.
Thank you, Councillor, and good afternoon, everyone. I think the key change, obviously, is the application that originally came in was for a specific use with a specific volume which had conflicts of coming and going. We originally also said that obviously the National Planning Policy Framework, to use its full title, obviously asks for pedestrians, cyclists, etc., to be considered in developments as well as car drivers. So we pointed out in that initial first response, which I think was about a year ago now, that the site is in a rural location. It can't cater for pedestrian or cyclists going there easily, especially pedestrians. There's no footways. It's unlit, so it would probably be car-borne traffic. The original proposal, we felt, was, given the width of the access drive being single track for the vast majority of it, once it was off the highway, had risk of conflict of those trying to get in and those trying to get out. So what has changed, obviously the applicant has, as just explained, have downgraded their use, have created an hour's gap in between sessions. So therefore the traffic volume has reduced. There is even less chance of a conflict now. And if there is that ad hoc movement, there's passing bays there, etc. So whilst we haven't gone away from, you still can't walk there or cycle easily, as the officer has put in her planning officer's report on planning balance, and as a consultee, that's again what we have to look at in terms of the NPPF. On balance, yes, somebody could cycle there if they wanted. Pedestrian would be difficult, but they could still do that now. There's nothing stopping them. We're just highlighting the fact it's not in an urban location. It would be car-borne traffic that would generally go there. And given that amendment to the use, there would be less traffic, there would be less conflict. So again, using the powers within MPPF as a consultee, as a highway authority, we only have limited reasons to object to a planning application. Given the amendments that have been made, we felt that the amendments were acceptable, and we didn't think we then had an argument in the framework, in the MPPF, that if we were to go to appeal, we felt we could defend. And I think that was what has changed.
Chair, so if I could just say, so the fact that the officers have negotiated the downgraded use to 3 or 4 times a day with an hour in between each, and the passing places are the main reasons that you have changed your opinion in that, from objecting to supporting, I guess. Yeah.
Yes, the use has become less, the traffic impact has become less.
Councillor Whittaker.
I'm a bit concerned about the way that's, because looking at it, it's a self-imposed reduction in numbers by the applicant. And unless we will like, put some sort of limit or whatever on it, I can't see how that can possibly be implemented or regulated, which I find a bit worrying. Obviously, I admire any diversification in the countryside and anything that's going to educate the next generation to rural pursuits. So I'm in favour of that. Regarding the access over the private ground, is there any restriction? I know we did hear that there was no restrictions or whatever on that. Is that the case in legal terms, that no matter how many people access our site, it is okay in the eyes of the law or in the eyes of the landowner?
Sorry, so in terms of the first point that you raised, in terms of the control point, so that's set out in the condition. I think it's condition 2, is that right? So in terms of, from that point of view, if they were to breach that, if they were to go above their sessions, if there was any complaints, a breach of condition notice could potentially be issued. So that can be controlled, and that'll be done by the condition. Sorry, if you could just explain the second question that you raised. I didn't quite follow the question, that's all, sorry.
The second was on the private ground, which is the access to the site. Yeah. That there's no, the person who owns that site has got no control over the numbers, volume, or anything coming over that site.
Right, okay. I think in terms of that right exists, from my understanding, in terms of what was read out, so that would be just a right to pass for everybody. So I think that's not, it's just a general right, because it's not conditioned in any way and controlled. It would be difficult for anyone to try and argue against that. So I think that's, yeah, you're stuck with the wording as it is, unfortunately.
Given the first explanation there, who's going to police it? That's my worry, because it's virtually retrospective. It's been running for probably 2 years with no controls at all. So it just worries, unless we put some conditions on hours use or hours open or whatever, I don't see how it's ever going to be brought to anybody's attention.
Yeah, fine. Oh, sorry. Yes, so condition 2, this is on the update sheet. So condition 2 relates to the operation to be carried out in accordance with the supporting statement. And then we've specifically added, it says, which includes the following operational details. So it limits the session times to those to 4 a day, not later than 5 o'clock, and also to a maximum of 8 guests per session. So if it did go beyond that, we could enforce a breach of condition. But it would rely on, I suppose, being notified of a breach. We wouldn't like monitor it as a matter of course. But if we received complaints, we would build up that case and enforce that.
I think, sorry, just to add to that point though as well, in terms of from a planning enforcement point of view, that's no different to any other planning enforcement issue. You rely on members of the public to notify officers of any complaints, and then they therefore go and investigate them. It's not any different to any other application, across the country. So that's generally how planning enforcement works.
Councillor Whittaker, did you want to come back, or are you satisfied?
Just to stay on that term, I mean, I presume the glamping and the farm educational thing will be quite a seasonal thing. So you just wonder whether there's going to be a closed season for this, there could be sort of operating procedures for certain months a year, whatever, just to give the neighbours a little bit of time when it wasn't, you know, to be assured that it was only farm traffic going down there or not. Would that be too prohibitive to the business?
The statement that's been provided doesn't restrict it seasonally. It just says that in terms of seasons there might be fewer experiences per day. So it's limited to 4 in peak season and then 3 outside of peak season at the moment. There's nothing else. And in terms of the glamping, that is permitted development, so we can't consider that at this stage because that's a separate matter.
Councillor Jones.
Joe, can I just, without planning permission, or with this turned down today, can they still operate 28 days a year? What's the impact of that, and what can operate for 28 days in a year without permission? Because that seems to be the way they've been operating at the moment under that bit of legislation, I guess.
If you can just give us a couple of minutes, I'll read out what the legislation states, but I understand it's 28 days per calendar year for certain operations, which this would fall within, but we'll just get that up.
So this operation would just be the animal part of it, not the glamping and all the rest of it. The 28 days would just apply to this, or weddings or whatever else you wanted to do. That would be included, would it?
The 28 days would not affect the glamping because that's separate, that's permitted development, so it would be for this particular use that we're looking at today, yes.
Chair, could I just also add to that, for the 28 days per year, with the restrictions and conditions that we're looking to add, would they apply then or not? So the 3 or 4 sessions per day, with the hour in between and the like, would they apply to the permitted days? Do you understand that?
Yeah, no, that's fine, yeah. So in terms of the permitted development order, that would just be a general right. There wouldn't be any limitations. There would only be limitations set out within the statute, but they wouldn't be limiting it like the condition is limiting it in any way, shape or form. So
they would be able to do more?
Yeah, potentially, yeah. I'll bring up the legislation as well, but I don't think it has any such condition that would limit it to 3 or 4 sessions and the timings, etc.
So the legislation, just into response to that question, the legislation only is more restrictive to certain matters, and that includes holding a market or motor car or motorcycle racing. Those are limited to 14 days, but other uses would be the 28 days per calendar year.
With no restrictions in the number of times per day, it was just the whole day could be used from dawn to dusk.
Yes, that's correct, yeah.
Okay.
Thank you. Do you have any other committee member? Councillor McKiernan.
Hi, thank you. I'm still not clear about the ownership of the access to the main road, because the first objector said it was a private drive that they owned, and then the applicant is saying it seems to be a free-for-all, anyone can come and go. Can we just clarify that? Because I'm worried there might be a case that if it's the case that the owners of the barns own the right to the main road, that they could perhaps block it, because they've already talked about putting bins and things in the way.
Yeah, so it would be a civil matter, the blocking of any road, but as Mr Sturman mentioned during his speech at the beginning, he said that he owned Forest Barn and that part of the access road, but the applicant has got right of access across it.
Thank you. Do I have any other committee member wishing to come in on the debate? Councillor Whittaker.
Just come back on a couple of things. Is the gate to remain shut then? If that's is that the transition from the private road to their own drive, or will that be replaced? Because I mean, if you've got cars backing up there to go down to it, it could present initial problems.
There's nothing in the proposal that says it's going to be removed or kept open, but there might be some logic to, you know, when the events are going on, that it is open, so then that stops that from happening, or, you know, reduces the risk of cars backing up. And then it could be shut again at the end of the day.
Yeah, I mean, going back to the whole application day, it's quite difficult to understand it, because I think we've not seen it at its best, because we've seen it in the middle of winter, basically, aren't we? And I think the sort of whole perception from our point of view is not the same today as it would be in the middle of May, June, when the lambs are in the field and there's grass and it's sort of clean and tidy. And I think a lot of this is about the public perception. So obviously, if it's the public perception, you know, it's got to be right. And I would have some concerns about some of the approach to the site, and I'd like to see it sort of. I know that's just a housekeeping thing, but I would sort of, if you're going to invite the public onto the ground and sell the whole concept, I think it's got to tick a lot of boxes. But same as I say, we're viewing it at a different time of the year. It would be totally different in spring.
Thank you. Do I have any other committee member? Councillor Holton.
Thank you, Chair. I wanted to ask, it's quite a large area, and as we visited for the first time today at site, has there been any consideration or any proposals put forward for an alternative access to the farm? Is that a possibility? Is that something that's been looked at before by the applicant?
I don't believe it's been considered as part of the application, but looking at the red line that's provided and the land in the applicant's ownership, it doesn't look like there are any opportunities to provide an alternative access point, given that it would have to cross a third-party land again.
Okay, Chair. Thank you, Officer. You mentioned third-party land again, so it already crosses third-party land.
So the access to the site is within the ownership of Mr Sturman, as mentioned at the beginning. So the first part of the access is owned by the neighbour, and the applicant has right of access across it.
Just to clarify, it's this section here. And then when we went through the gate this morning, that's when it becomes the applicant's ownership. So the applicant has a right of access on this first section.
Yeah, that is understood. But again, I'm just looking at the whole site and not knowing it well. Have we ever considered, or has the applicant or neighbours considered a possibility of another access into that area, is what I'm asking.
Not as part of this application, no.
Okay, the other question, if I may, Chair, is going back to what colleagues are raising there, seasonally, I'd like to consider putting forward a proposal then for outside of the 28 days to propose the businesses run seasonably and perhaps to admit the winter months as we've seen it today, and perhaps run in line with spring and summer. Just to make light of the fact that they're the best of bad situation, really. So they have some reprieve during the winter months, the neighbours, and that the applicant can indeed have a viable business during the summertime with some possible conditions.
Yeah, sorry, any alteration to the condition in terms of limiting the use would need agreement from the applicant.
Okay, thanks, Chair. Are we able to ask at this point, or does that have to be put forward by the applicant? Are we able to ask the applicant if they would consider that?
Wouldn't be appropriate to agree that at the moment.
Okay, thank you.
Councillor Huckabee.
Thank you, Mr. Chair. Could the officer expand on the strength of the right of access across that beginning part of the road?
The actual right of access is a civil matter and not a material consideration. But as I've said previously, it's the access at the beginning part on this section here is owned by Mr. Sturman, who spoke at the beginning of the meeting, and the remaining part is in the applicant's ownership, but the applicant do have right of access across this, as Mrs. Rose read out at the beginning.
Do you have any further questions? If not, if you could turn your mic off.
The reason why I ask is obvious, I think, to everybody, that if the strength of that right of access is weak, then we'd be given planning permission for something which was not viable. I understand this is a legal matter and you're not legal people, but I would have thought it was something which we would have been briefed about.
So the applicant does have right of access, and as we heard earlier, and Nikhil answered, it is kind of unlimited access, so there's no restrictions on that.
Councillor Legg, did you wish to comment?
Yes, please, Chair. Thank you. I'd like to echo Councillor Whittaker's comments. I do visit quite a few petting zoos and farms because I have young grandchildren, and I was quite appalled by the state of the piles of things, and even though the animals looked happy and were pleased to see us because they came to the fence, I felt that it did look rather untidy. Thank you.
Thank you. Councillor Whittaker, did you want to comment?
I'm just interested to know why it's not appropriate to put a condition on months of usage at this point, because that's, as far as I'm concerned, that's a big thing of whether I support it or whether I don't support it, because I just think it's a seasonal business. Would for permission, they would have a problem with restricting it to the winter months, to the summer months, sorry.
I think the point is that it would need to happen in consultation with the applicant, and I don't think the appropriate place for that would be during the planning committee. I think that's the point. So in terms of, from an options point of view, you've got the option of the application before you. If that's something that you want to propose, maybe the deferral would be a consideration as well. So that discussion could be had with the applicant in terms of the viability of the actual business and the proposal that they're putting forward as well.
Councillor Huckabee.
Yeah, just to say that within the content of the application, there is an intention there in inclement weather to move the familiarisation stage of the process indoors, so that they obviously recognise inclement weather when it's coming along and have worked out a plan of where to hold that. That's not saying I agree with it or whatever. I'm just saying, in point of view of your restrict it to a particular period where the weather is good for outside, they've already accounted for that.
Can I just say, Chair, that it does rain quite a lot in the summer in this country.
Thank you. Do we have any further speakers on the item? Councillor McKinnon.
I don't know whether it's a planning matter, but I'd just like to understand a little bit more about the licensing of the animals for entertainment. I'm not sure what it's for. It's just in towns, for instance, the RSPCA. You're no longer allowed to go and look at the animals, so we seem to be moving away from animals as entertainment, as it were. But it is mentioned in the officer's report, so I'd just like to understand a little bit more about the basis for it. Is animals in the country different?
We don't have any information in respect of that. It was just a comment from the environmental health team that they had no objection, and they pointed out that it was subject to a licence.
If I could just jump in, I don't know if the applicant does this, but you would need one of those licenses. Say if you were going to take an animal to a show, just to show them, you would need that licence. So it might cover that scenario as well.
Thank you. Do we have any further speakers before we move over for recommendation? Yeah, Councillor McKinnon.
So do I understand we have an option to go for a deferral in order to ask the applicant about the opening hours?
Yep, that would be a decision for the committee members. So if that motion was put forward, seconded, and that's what members feel that is appropriate, then that could be done.
Chair, I'm happy to put that forward or support a deferral at this stage.
Would you be happy to second that, Councillor McKinnon?
Chair, before we vote, can I just ask what exactly it is we're going to be deferring for? Whether are we specifying when we think it should not be operational, like I don't know, November, December, January, or what are we looking for from that deferral?
So I think it's up to members in terms of kind of putting forward a proposition in terms of what the planning manager is going to have to discuss with the applicant, and what the kind of criteria is.
Still need that spelled out for us.
Yeah, there needs to be some kind of motion in terms of this is what you're aiming for.
Okay, thank you.
So, Councillor Whittaker, obviously you're proposing the deferral. So if you can just outline the proposal of the deferral in terms of wording what you'd like, and then we'll move to vote.
Yeah, propose a deferral because of the issue over the seasonal opening of the site for the use as specified. And we'd just like a dialogue with the applicant concerning that in the meantime.
Yeah, I think just for the purposes of clarification, when you mean seasonal opening, are you thinking kind of spring and summer months only? You know, what's your kind of thinking, just so that it's clear in terms of from an instruction point of view and from a voting point of view as well?
Yeah, as a guide, I would say the 3 months, November till January.
Yeah, that's fine, thank you.
Councillor Huckabee, in the meantime, did you want to come in?
Yeah, I was just wondering about the proposal that's been made by Councillor Whittaker, whether it's born out of the comment made by Councillor Legg that the place looked untidy. I have to add the point that it is a working farm and it is during the winter. Therefore, these sorts of untidiness are natural to a working farm, no doubt. I've been on a few. I've not been on every one, but I would just like to make the point that, you know, winters and summers and autumns and springs have a different state of viewing. As you made before, that you go there in the summer and the trees are full of leaves and the young lambs are scampering about, and things do change during the seasons.
Councillor Whittaker.
Yeah, can I just make a comment on that one? Because I'm perfectly aware what a farm's like in the winter. I'm also perfectly aware that the farm will carry on running all the time this was implemented. And I haven't been a farmer all my life. I know exactly what it's like, and we all have untidy corners, but when you invited the public on board, it's the public's perception to that site, and I think we have got to guarantee that by but change it. Have we got to go to deferral this out, or can it be resolved by talking to the applicant and going through commission? Because I'm just a bit curious on that.
It's just because you know, the applicants obviously propose what they think is financially viable for their business. So what, you know, they'll have to go away and number crunch in essence and see whether what committee is saying today is acceptable to them or not.
And that can't be done with a German now and talk to the applicant.
Yeah, I don't think it would be an appropriate thing to do, just because I think it would put kind of unnecessary pressure on the applicant to kind of agree to something which they may later regret. So, you know, I think it's a point of fairness, that's all.
Councillor McKiernan.
I was happy to second the motion. However, I wouldn't be hard and fast about November, December, January, only for the case that I know that some people make their income during the Christmas holiday break, and it may be that they would like to have the farm open during those 2 weeks when the kids are on school holiday. So I'm happy to second it as long as it's a general discussion and we can arrive at a compromise.
I mean, from the previous discussion, Lisa and I suggested that the wording for the deferral would be for the applicant to consider the use of the site in terms of seasonal opening of the use, in particular consideration of, I suppose, not using the site between February, particularly limiting the use of the site between February and October, but it could just be limiting it to 9 months a year, for example.
Councillor Jones, was you indicating?
Yeah. Meanwhile, from the 1st of January, the applicant can start on their 28 days permitted use again, I guess, for the next calendar year, because if this is deferred, it won't be back to committee before the 1st of January, will it? Is that right?
It depends when the first event started, so it's, they might...
Sorry, I thought you said it was per calendar year.
Yes, but I don't know when the first one, so it might, they might have done 28 in 6 months, for example.
I just want to avoid them having even more of a problem.
Councillor Huckabee.
Yeah, I'm just wondering about the legality of whether or not we're able to intervene into the supply and demand laws, natural laws or whatever, which govern trade in this country. If the supply is there and the demand, you know, do we have a right to actually involve ourselves in this particular scenario?
It's no different to adding conditions for, you know, trading hours for a shop. You know, in terms of, for example, you've got construction sites, those are controlled in terms of, you know, planning committees control the conditions in terms of when that work is done. The fact that it might not be done on a Sunday, can't be done on holidays, that's just part and parcel of the planning process, and that's why it kind of exists in terms of limiting what can be done on land by taking into account the interests of others. So that remit does fall within, you know, the remit of planning committee.
Thank you. Before we go to the deferral motion vote, does any other member wish to come in? No. Right. Councillor McKinnon.
Sorry, but can you not put my feelings in there as well? You know, that it can close from. I don't see why it has to be precise dates.
No, the deferral will be, I suppose, putting the onus on the applicant to consider a seasonal calendar,
And that
whatever that might be.
And that will give them the option of an open discussion with you.
Yeah.
Yeah. Okay.
So, Councillor Whittaker, you happy with that? Yep. All right. So
Yeah,
we've got a proposer, we've got a seconder. So all those in favour of the deferral? Any against? Five for the deferral. Right, okay. So we've got 5 for the deferral and 4 against, so the deferral motion has been passed. So move on to the next item on the agenda. Move on to the next item, I guess.
Yes, right. It was 5. Yeah. There's 2 on this side, 3 on this side.
Yeah. Okay. Thank you. Before we move on to the next agenda item, would any member of the public wish to leave? They can do now. Thank you. Moving on to agenda item number 6. Can I request members to consider the appeals received and determined? Is that noted? Thank you. Moving on to agenda item number 7. Request members to consider the planning permission circulated with the agenda. Is that noted? Thank you. We'll now move into the private part of the meeting. If I could request the press and public to leave the room, that in accordance with section 100A of the Local Government Act 1972, the press and public be excluded from the remainder of the meeting, as it is likely, in view of the nature of the business to be transacted or the nature of the proceedings, that there would be disclosed exempt information as defined in paragraphs of Part 1 of Schedule 12A of the Act, indicated in brackets before each item number on the agenda. Do I have a seconder? Councillor Whittaker. All those in favour? Thank you, that's unanimous.